Types of legacy. Specific legacy. This is a gift of an identifiable property that is distinguishable from the other properties owned by the testator. The exact gift given without doubt as to its correct identity. The gift may be indicated by the use of the word mine followed by the perfect description of the gift. Examples are as follows: a gift of my Toyota Camry car with registration number BQ123BN to my daughter Priscilla. I give my diamond ring bought from Jay's Empire's Jewelries to my cousin Ifoma. A gift of my 4 million naira worth of shares in Access Bank PLC to my son Kenneth. Take note that it's not a specific gift if it returns a Toyota car to my son Dio. Disadvantages of a specific gift. If the gift is no longer available at the time of the testator's death, it will be said that the gift is redeemed and consequently has failed. Due to the doctrine of redemption, specific gifts is usually avoided. In order to avoid its failure, alternative or substituted gifts are made to the beneficiary, e.g., a gift of my Mercedes-Benz with registration number LA123ASB. If it fails, I make gift of my Toyota Hiace with registration number LA456ASB to my son John. However, care should also be taken to know that specific gifts are not subject to abatement. Abatement means the reduction in the character, quality, and diminution of the gift. General legacy. There is no specific description. It does not refer to any particular piece of the testator's estate. The testator intends that the gift should be satisfied from the general asset of the estate. Example, a gift of my walking stick to my son Joel. If the testator does not own a walking stick at his death, the executors will provide for it from the testator's general estate. Note that gifts of shares and stocks are generally referred to as general legacies, except where the testator particularizes the number of shares and the companies from which he bought them. A general legacy is not subject to redemption. The testator does not have to own the property at the time of the making of the will. Demonstrative legacy. This may be in form of general legacy but directed to be satisfied from a specific fund or particular pool of property. Example is: give $5,000 to Kenneth to be drawn from my savings account 2059835985 Michael Onochada at United Bank of Africa PLC. The formula for a demonstrative gift is spelled out as follows: gift plus description plus source. Demonstrative gift is not subject to redemption and will only abate where the particular fund is not sufficient to take care of the legacy. Example: a gift of $2 million to my daughter Nicole to be paid out of my account 0058264664 Michael Onochada with Sterling Bank PLC. Demonstrative legacy is not limited to gifts of money. Example: a gift of my books kept in the shelf in my bedroom. Pecuniary legacy. This is strictly money dispositions. It could be general, specific, or demonstrative. It may or may not give direction of the particular fund where the money should be drawn from. If it gives directives on where the money should be drawn from, it is demonstrative legacy. Example is: I give $50,000 to my wife Debbie to be paid to her every month, and money includes cash and notes at hand, money immediately payable to the testator at call, and money at the bank. However, money cannot be extended to include shares in a company. Residuary legacy. This is the remainder of the property belonging to the testator after payment of all other gifts and debts and liabilities of the testator have been fulfilled, cleared, or paid. It is made up of personal or real property. A residuary clause is usually inserted in the will to transfer all remaining residue back to the estate. Such remainder may have been derived from the following sources: a. Property acquired by the testator after the making of his will or after his death. B. Gifts that lapsed by the death of the beneficiary. C. Gifts that failed. The beneficiaries are called residuary legatees. Residuary legacies reduces the possibility of partial intestacy. Absolute legacy. No conditions attached. It vests automatically and takes effect upon the death of the testator. Conditional legacy. The gift only becomes effective upon the happening of a particular event. Situations where a gift may fail. Lapse. In a situation whereby the beneficiary predeceased the testator, the gift will lapse. The estate already devolved will fall back on the general estate of the testator. Illustration: Chief Ojo made a gift of his house at number 5 Windsor Street, Asaba, Delta State to his third wife Eunice. If Eunice dies of hay fever while Chief Ojo lives, the device to Eunice will be said to have expired and consequently will devolve on the estate of Chief Ojo. If both Chief Ojo and Eunice dies in an accident together, the gift to Eunice does not lapse because it will be presumed that Chief Ojo, being the older amongst them, died first. An older person is deemed to have died first before a younger person when there is confusion as to the time of their death. To this effect, the gift to devolve upon Eunice's successor. Lapse cannot be excluded in a will. Section 16 sub 2 of the Evidence Act 2011. For the purpose of determining title to a property where two or more persons have died in circumstances in which it is uncertain who survived the other, they are presumed to have died in the order of their seniority. If the beneficiary, however, is older than the testator and they died at the same time, it is presumed that the beneficiary died first and consequently the gift will fail. Exceptions to the principle of lapse: 1. Where the witness to the will is a mere trustee and not a beneficiary. 2. Class gifts: where the gift is made to two or more persons, so long as a member survives, the gift will not lapse. Note that where all of them died at the same time, it is presumed that the youngest of them died last and the gift devolves to his successors in title. 3. Gifts to settle debt or moral obligations will not be affected by the doctrine of lapse, whether or not the obligation is legally binding. 4. Whether it is substitutional or alternative gifts, e.g., I give my Toyota Camry with registration number LA1 to 3BN to Kenneth or Nicole. If Kenneth predeceases the testator, Nicole shall have the gift if she survives the testator. 5. A declaration against the application of lapse, but which must be accompanied by a substantial gift. 6. Gifts to a testator's child who dies in the lifetime of the testator but has a child who is living after the death of the testator. Section 33 of the Wills Act, Section 24 of the Wills Law. The gift is not determined by the death of the beneficiary because the beneficiary had a child. Ademption. This is where a gift ceases to exist at the time of death of the testator. Situations when ademption will occur are: A. Where the gift is lost or sold. B. Where it is extinguished by claim. C. Ademption by operation of law. D. Ademption of a property which is subject to a contract of sale. E. By subsequent disposition by the testator of the subject. Abatement. This is a reduction, decrease, diminution in the whole or part of a gift. Disclaimer. This is when a beneficiary under a will disclaims, refuses to take a gift made to him under a will for personal reasons. Thus, a gift in a will or settlement inter vivos can be renounced by the beneficiary. A disclaimer can be oral or in writing. F. Gifts made contrary to the provisions of Nemo dat quod non habet. In this situation, the testator does not have a valid title to the property which he devised as a gift. G. Uncertainty. Where a beneficiary is not clearly described and is uncertain, or the property is not clearly identified, the gift may fail. It is important to know that a gift for charity will not fail for uncertainty. A perfect example is a gift to religious societies. H. Public policy. Generally, a beneficiary's character or lack of character will not affect his capacity to take a gift made to him under a will, but where the beneficiary is responsible for the death of the testator, or where the gift is made to incite divorce or for an immoral purpose, the beneficiary will be prevented from taking the benefit accruing to him from the will on the grounds of public policy. Revocation of wills. Revocation of a will has the effect of annulling the content of the will so that it never takes effect after the death of the maker. Revocation may be voluntary or involuntary. Voluntary revocation. A. Executing another will or codicil to revoke the provisions of an earlier will. The words of revocation in the codicil should also be clear. This can be clearly stated by inserting the revocation clause in the new will. B. A written intention to revoke which must be properly executed and attested to by two witnesses present at the same time. It includes a memorandum of revocation, a letter, a settlement, or an ordinary declaration of intention to revoke the will. It must be executed like a will. C. Destruction by burning, tearing, or otherwise with the intention to revoke the will. The marriage here is not marriage under the customary law, Islamic law, but is subsequent statutory marriage, Section 18 of the Wills Act of 1837. Exceptions to the rule of revocation by marriage: A. Void marriage. B. Wills made in contemplation of celebration of marriage, Scalise and Jones 234 U.S. 615 1914. C. Customary law or Islamic law marriage. D. Where there is appointment, the will is not revoked by the testator's subsequent marriage unless the person stake in default of appointment takes as the testator's heir, executors, or administrators. Jadesimi and Okotiebo, SC 188 1992. Revival and republication of wills. This is the act of bringing back to life or operation a revoked will of codicil so long as it is not destroyed. This may be done through A. Re-execution with the formalities duly complied with, or B. A duly executed codicil with the intention to revive the revoked will. Take note that there must have been a will which was revoked. If there was nothing revoked, there can be no revival. Reference must also be made to the will that was revoked. Republication of a will is the confirmation or reaffirmation of the validity and contents of a will. Republication confirms a will which has been lying dormant and yet unrevoked. Republication changes the date that the will take effect. The will thus will take effect from the date of the republication and not the date on the original will. Quick glance note is powered by Rooms and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 081-427-7545, and send your emails to ronumsandluxury@gmail.com, Instagram Ronums and Luxury, Facebook Ronums and Luxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 091-259-21620 or send an email to resistandpartners.chambers@gmail.com.